on murder hornets. All right, well, good morning. And so Anne Reed had told me this morning before we came into work that we had one of those fake backgrounds of the ocean. So here I am ready for this. And
I deny that.
all right, so I'm going to be speaking today about the National Labor Relations Board and give you some updates there. I'm sure as everyone knows that daylight savings time was about 2 weeks ago now, and that is our theme for today. And it will become clear as we go through some of the updates. National Labor Relations Board update is appropriate for everybody because even if you don't have a union in your workplace, Section 7 rights still apply to your non-unionized employees. So these standards are important for everybody. All right, so getting to the first standard. The first standard is addressing offensive outbursts, which I believe Josh had just mentioned. Now, on July 21st of this year, the NLRB decided General Motors LLC case. It basically modified the standard for determining whether outbursts are protected activity. Now, previously, there were different standards based on the type of interaction. So if you had an encounter with management, it depended upon the context of the encounter. If you had an exchange between employees and postings on social media, you use the totality of the circumstances test. And for offensive statements that actually occurred on the picket line itself, pretty much anything went, and it didn't matter how extreme it was. If you're on the picket line, you were allowed to do it. So these tests gave the employees a lot of leeway, and it really depended on the situation, and it protected some really, really offensive conduct. So now the board has decided that cases involving offensive and abusive language will be decided in the under the right line test. Basically, it's a two-step question there. General counsel for the board first must prove that the employee's protected activity was a motivating factor in any discipline that follows. And if that's the case, the employer gets to come back and then prove that it would have taken the same action in the absence of the protected activity. So that's a more management-friendly test. Definitely more friendly to management. Okay, pre-contract discipline. So on June 23rd of this year, the NLRB decided 800 River Road. This case overturned a 2016 case called Total Security. So since 2016, the way it was is that after a unit is formed, but before a contract has been agreed upon, so you're still in that negotiation period, management was required to provide the union with notice and opportunity to bargain about potential discipline where there was an existing disciplinary policy before they could impose serious discipline on an employee. So that was the old standard. The new decision in 2020 goes to reinstate a longstanding practice that is not a violation for an employer to exercise its discretion in issuing discipline that's consistent with their pre-existing disciplinary policy. And basically, the employer and the union would have to go and negotiate their contract in due course to decide upon any new disciplinary policies. So this is another case that turns back time a bit. The third category is joint employer role. I think joint employer role is important because if you are deemed to be a joint employer, then you're required to bargain with the union that represents the jointly employed employees. So you can be both charged with unfair labor practices, and you don't want to be a joint employer if you can avoid it. So there was a final rule went into effect on April 27 of 2020. The rule basically revised the joint employer standard that existed prior to 2015. Now in 2015, the board had decided a case called Browning-Ferris. Under Browning-Ferris, a business could be deemed a joint employer if it exhibited indirect control over another employee's conduct and or it reserved the ability to exert such control. So that was a very, very broad test, and it was creating lots of joint employer contexts. Under the new rule, to be a joint employer, a business must share or co-determine the employee's essential terms and conditions of employment. So that means it must meaningfully affect matters relating to the employment relationship, and it must possess and exercise substantial and direct immediate control over one of 8 or more core aspects of employment. And those core aspects of employment are wages and benefits, hours of work, hiring, discharge and discipline, and supervision and direction. So this new old standard is much more limited, and it's definitely far more favorable for employers. All right, an employer's right to restrict the use of email. On December 17 of 2019, which was after our last seminar, the NLRB decided Caesars Entertainment. This case basically overruled Purple Communications, Inc. Purple Communications had been decided in 2014, and it basically held that where an employee was given access to an employer's email system for work purposes, the employee had a presumptive right to use that email system during non-work hours for communications that were protected by Section 7 of the Act. That's going to be any type of joint communications or communications designed to work in concert with others. Now, the Caesars case held that employees do not have a statutory right to use the employer's email to engage in non-work related communications. Employers may control the use of their equipment provided they do not discriminate against the union or other protected communications. So if you're going to allow some employees to use the email system on their off time for personal purposes, then you can't prohibit the employees from using it for union purposes. But as long as you are prohibiting everybody from using it for non-work purposes, then you're good. There was an exception made for where the employer provided email is the only reasonable means for connecting with other employees. So that may apply to some businesses that are very spread out. But for the most part, it's going to restore the register guard test that had been in place until 2014. So a red flag. I know what a red flag means.
Do you anticipate any major changes with the NLRB as a result of the presidential election that just came in?
Absolutely, absolutely. The pendulum has gone to one side. There are 4 sitting board members out of 5 places. So eventually, people are going to go off the board, and the new president is going to be appointing new members. So I anticipate that we'll have some more liberal members of the board return, and the cases will get interesting for a while and probably swing back to the other side. Now, I'm not sure if some of these long established cases are going to be overruled again, which would make our lives very difficult, but I suspect that the trend of conservative decisions is going to come to an end in the near future, not immediately, but as the composition of the board changes, it will change.
Thank you.
Okay, confidentiality in the workplace, in workplace investigations, that is. So on December 17 of 2019, the NLRB decided the Apogee Realty case, and that addressed rules regarding confidentiality during workplace investigations. Now, this case overturned a 2015 decision called Banner Sterling Medical Center, which had held that the burden was on the employer to prove that the integrity of the investigation would be compromised without the confidentiality. Now, Apogee decided, no, that's not the standard we're going to use. We're going to apply the test for evaluating any facially neutral workplace rules. So it established 3 categories of rules that you could possibly have. The category 1 are lawful rules, because either a reasonable interpretation of the rule does not prohibit or interfere with the exercise of NLRA rights, or B, because the potential adverse impact on rights is outweighed by the justifications associated with the rule. So that's category 1 rules, which are permissible. Category 2 rules require individualized scrutiny to determine whether it would interfere with rights, or if the any adverse effect is outweighed by the legitimate justifications. And then category 3 rules are basically rules that are unlawful because they either outright prohibit NLRA protected activity, or the adverse impact is not outweighed by justifications. So the Apogee case held that facially neutral investigative rules that say you have to be confidential in investigations may affect the rights, Section 7 rights, but any adverse impact is comparatively light. So this falls into the category 1B types of permitted rules for open investigations only. So if you have any sort of confidentiality rules regarding investigations, then you're pretty much going to be able to follow them as long as you are applying them to open investigations and equally neutrally. Okay. Union dues checkoff on December 16 of 2019. Again, the NLRB decided Valley Hospital Medical Center, it overruled changes to dues obligations at the end of a collective bargaining agreement that were created in 2015 by Lincoln Lutheran of Racine. This restored the procedure that had been in place since 1962. So absent a contract, there is no independent statutory obligation to check off and remit employees' union dues after the expiration of the collective bargaining agreement. So it basically, once your agreement ends, then your obligations with regard to union dues ends as well. As you can see, all these cases are rolling back time to an earlier age, and maybe we'll have a jump forward in the future. All right, how much time do I have?
5 minutes.
5 minutes, okay. Jurisdiction over religious institutions. This is one of the few areas that actually implicates the jurisdiction of the NLRB. They have no jurisdiction over religious institutions. So the question is, how do you determine if something is a religious institution? Now, in June 10, the NLRB decided Bethany College, which overruled a 2014 case called Pacific Lutheran University. Under Pacific Lutheran, which has been in place for the last 6 years, management had to prove that the First Amendment concerns that are implicated by showing that it holds itself out as providing religious educational environment, and that it holds out faculty members themselves as performing a specific role in creating or maintaining the university's religious educational environment. So that's a very difficult thing for, not very difficult, but it certainly is a increased burden on management to prove that their individual staff members are actively promoting the religious-based doctrine. Now, the board must decline to exercise jurisdiction over a university that holds itself out to its students, faculty, and the community as providing a religious educational environment. The business or the university is organized as a nonprofit, and it's affiliated with, owned, operated, or controlled by a recognized religious organization. So the individual inquiry about individual faculty members has been removed, and that should make it much easier for religious institutions to take advantage of the lack of jurisdiction over them. Okay, the last section I'll deal with very quickly have to do with election rules. Election rules can get kind of complicated, but they were amended in December of 2019 to loosen up some of the very strict provisions that had been added over time. These rules were challenged as being unlawfully promulgated, so there's nothing necessarily wrong with the rules, except for the challengers were saying that you didn't follow the correct process for enacting them. So in May of this year, the United States District Court for the District of Columbia issued an order which basically said that 5 of the rules were not properly promulgated and put those 5 rules on hold until they can go through the process again. Given the current composition of the board, maybe that will happen, maybe it won't, but I think it probably will. The 5 regulations that are not in effect deal with giving the parties the right to litigate over voter eligibility prior to having an election. For right now, the old rule remains in effect that disputes about voter eligibility are addressed after the election. The election will not be scheduled for less than 20 business days after the direction of an election by the director. The old rule remains in effect for now, that the election will be scheduled at the earliest date practicable. The requirement that the voter list be provided to the regional office and the union within 5 business days, that was put on hold, and the old rule remains in effect for now, that it must be provided within 2 business days. The rule about election observers being limited to current members of the bargaining unit has been put on hold. And right now it goes back to the prior rule of parties may choose their own observers. And the Fifth rule is that the regional director will not issue a certificate following an election if there's going to be an appeal. And for now, the old rule remains in effect that the certification can issue even if there is an appeal. So as you can see, all of those rules that were proposed were basically loosening up the very tight timelines for employers to respond or compelling the process to move forward, giving us a little bit more breathing space. But for right now, those are going to be placed on hold. The rest of the rules, I'm glad to say, have gone into effect, and I won't go into exactly what they are in the materials. You're welcome to, and I'm sure you'll be happy to review them when time permits. So at this point, I believe we're transitioning from rapid fire 1 to rapid fire 2.